Commissioner Melendez.
I'll yield my time to Commissioner Yaki if he needs it.
I'll carry it over.
Okay, Commissioner Harriet.
I wanted to ask a question about the injunction that did issue. Why was the decision made to limit it to the city of Philadelphia? Why not the suburbs? It's easy enough for someone like Mr. Shabazz, if he's told he can't repeat this activity in the city of Philadelphia, to just hop on a bus. Why just the city? Why not?
Well, again, the legal principle is the principle of narrow tailoring. When you're seeking injunctive relief, the injunction needs to be narrowly tailored to address the underlying offense. Once the national party was dismissed based on insufficiency of the evidence, then the national injunction was no longer in play. And so the judgment was made by...
But there's narrow tailoring, and then there's narrow tailoring. I mean, sure, there are cases like Marshall versus Goodyear that talk in the abstract about narrow tailoring. And the Goodyear case, I think, is decided correctly. But we're talking about such a narrow tailoring that, the injunction is practically naked. It's really not useful to have an injunction that only applies to the city of Philadelphia. If someone like Mr. Shabazz is a wrongdoer, and I think you agree he's a wrongdoer, he's not so stupid that he doesn't know how to get on a bus. And at that point, he could repeat the same activity and not be subject to contempt of court, which is the whole point of an injunction like this, to be able to say if he does it again, well, this time, we can get him for contempt and, inflict some punishment there. But narrow tailoring wouldn't say you can't apply the injunction to suburban Philadelphia. I think, in fact, you could go much, much further than that. I think if you look at the cases, you'll find that we're way beyond narrow tailoring here. We're down to a naked injunction.
Well, I think what's illustrated from our back and forth, Commissioner, is that you and I and the decision makers have some profound differences of opinion on.
Do you disagree that it would be easy for him to get on a bus and go to the suburbs?
Well, he could go to New Jersey, I guess. So should we expand it to New Jersey? The evidence presented was that the new Black Panther Party.
Should we? New Jersey's very close to Philadelphia.
The evidence presented was that the new Black Panther Party, and in particular these two people, were involved in the city of Philadelphia. That was the evidence that was presented, as I understand it, to the decision makers at the time.
Well,
and
the
so,
under principles of in 2008, and it wasn't raining that day. Does that mean that it only should occur? The injunction should only apply if it's not raining, and it's 2008. I mean, you have to do these on a reasonable basis. If this conduct is repeated, under what circumstances would that likely be done? Why confine it in a way that becomes almost comical?
The city of Philadelphia is pretty big.
Not that big. I take it you have agreed he's capable of getting on a bus.
He is capable of getting on a bus, but we have to be...
and it wouldn't be very hard, right?
We have to be narrowly tailored in the way we enforce things.
Within what's reasonable. If you take a look at the case law on narrow tailoring of injunctions, you've really gone quite overboard here.
Well, I would respectfully disagree, and once again, we
what
have
about
a difference
the
of
Nicoletti
opinion.
case? What injunction are you requesting there?
They're going to jail.
Did you bring an 11B?
We did not, because we brought a criminal prosecution in that case, and they are serving jail time.
Was a criminal case considered in the new Black Panther Party case?
Yeah, the criminal case was considered by the local and the federal authorities, and prosecution was declined.
Other cases under 11B, do you have the injunctions that have been sought in those cases?
Well, again, there are only 3 cases that we are aware of that the government has brought. 2 of them were lost at trial.
Yeah, but even if they were lost, presumably you requested something.
Presumably something was requested, but you have to get liability before you can get the injunctive relief.
Yeah, but I'm interested
and there was no
evidently
liability.
Someone at the Department of Justice believed these were justified cases. What injunction did they request there? Did they request something that applied only to a particular city? Or did they request something further, like in the Nexaby case? The 11B case wasn't successful, well, presumably there was something ready to go, some suggestion as to what the
Well,
injunction
again,
should look like if it were to issue.
Each set of facts is different. In the case that was the most recent case, that was a case involving a individual who put an ad in a newspaper saying
Thank you,
if the
Mr.
following 20 people vote.
Which I
you,
assume
Mr.
he did only
Perez.
in one spot.
Okay, thank you, Mr. Perez. Commissioner Kirschner?
Yes, thank you. Mr. Perez,
Mr. Chairman, I just want to make sure, I have a commitment at 11:30, so I thought I was supposed to be here at 11, so I just want to make sure that the Commission's aware that I need to leave in about 5 minutes.
Thank you.
okay. Mr. Perez, again, thank you for being here. Thank you for your time. The remedial memo of, I think it was May 6th, or maybe it was May 9th of 2009, asked that the preparers determine whether or not there were any First Amendment implications to the conduct in which Shabazz and Jackson were engaged. Did the department come to a position as to whether or not their activity on Election Day of 2008 constituted protected activity under the First Amendment?
Well, again, as it relates to Mr. Shabazz, the determination was made that his activities constituted, I should say, Mr. Shabazz, who was at the polling place, because there are two Mr. Shabazzes in this case, that his actions constituted unlawful intimidation. The judgment was made that, as to Mr. Jackson, that his actions did not reach the evidentiary threshold necessary to establish that violation. As it relates to the National Party, again, there's no vicarious liability, so that, and the post-election statements from the National Party that they didn't condone the activities, statements of that nature were very relevant in the determination that we could not sustain the evidentiary burden against the National Party.
Well, specifically with respect to the First Amendment, was any of the conduct that we observed on the videotape of November 4th of 2008 protected under the First Amendment?
Well, again, as it relates to Mr. Shabazz, the determination was made that his activities constituted...
Understood. But was any of the activity that we observed protected?
Is any of the activity... Well, standing at a... If you're standing at a polling place absent other indicia of intimidation, that is certainly a protected activity.
There were allegations that there were racial slurs invoked, that someone was called a race traitor, and they were wearing paramilitary gear. Given the context, was any of that protected under the First Amendment?
Well, again, the determination was made based on the totality of the review that there was insufficient evidence as it related to Mr. Jackson. As it related to the National Party, when they made a statement that we're going out to 300, we're deploying 300 people to various polling sites, that is undeniably, in our judgment, protected speech in absent another statement that says something more than that. And
so, some of the discrete facts that we have here are we have two individuals who belong to what has been described as a hate group in military garb, with one of them having a baton. Racial slurs were invoked. There's evidence that at least 3 people, although it's unclear whether or not it was a result of Mr. Shabazz and Mr. Jackson's conduct, were deterred from voting, at least turned away from voting. And we have a circumstance in which the case was poised for default. If, and we see it on the videotape, if the public views this and then sees that there's no movement going forward on at least 2 of the defendants and a limited, very limited injunction, and we can debate that, but I tend to agree with my colleague that it seemed to be a fairly narrow injunction for one of them. To what extent do those facts go into a deliberation among persons within the section, division, or department that this may cause others to think that there's some concern about, or the department has a certain view as to how to proceed on these particular cases?